Welcome to the deep dive. Today, we're taking on a really crucial piece of legislation, one that reshaped how an entire country deals with its most vulnerable young people, the Child Justice Act of 2008. And this isn't just about digging into legal minutia, it's about a really profound shift in philosophy, how we view children in conflict with the law. We've got a stack of sources here, straight from the act itself, to really unpack its core. Our mission, really, is to explain this landmark act in a clear, engaging way. For everyone, general public, law students, anyone interested, we want to outline its purpose, key provisions, the legal background, how it works in practice, and, its real-world significance.
Absolutely. This act really is a landmark piece of work. It reflects a significant departure from older, often much harsher approaches to juvenile justice. It strives to align the justice system with the unique needs and rights of children, the rights that are enshrined in their Constitution and international obligations, too. And what's truly fascinating as you dig into it is how the act aims to promote the spirit of Ubuntu.
Ubuntu, that deep philosophical concept.
Exactly. Humanity towards others.
Right.
It's not just a nice idea here. It's actually embedded in the legal framework. It's about fostering children's sense of dignity and worth, reinforcing respect for human rights, and encouraging their reintegration through restorative justice, not just punishment. So our mission today, as you said, is to cut through the dense legal language. We want to show you what this actually means, revealing the underlying principles and the big practical shifts it brought about.
Okay, let's dive in then. Let's start at the beginning. What was the real driving force behind creating the Child Justice Act? Our sources talk about a history where many children, especially, Black children before 1994, weren't really given the chance to just be children. And the existing laws, they just weren't comprehensive enough, were they? Didn't really address their unique vulnerabilities in the justice system.
Precisely. And the preamble of the act itself is incredibly powerful on this. It explicitly acknowledges that past, a past where children were always treated as children, and where some came into conflict with the law simply because of the circumstances they were born into, their environment. So this act was born from a clear recognition that the old ways, well, they just didn't work. They often just perpetuated cycles of crime, didn't they? Right. So it's a very deliberate effort to break that cycle, to try and foster safer communities by encouraging children to become law-abiding, productive adults.
That shift feels deeply connected to fundamental rights. How does the Child Justice Act, intricately weave itself with the country's constitution, especially concerning those unique protections specifically for children?
Oh, it's absolutely foundational. The act is meticulously designed, really, to protect those constitutional rights. Things like the right not to be detained except as a measure of last resort, and even then, only for the shortest appropriate period. That's huge.
A last resort, okay.
Yes. And ensuring children are treated in an age-appropriate manner, that they're separated from adults if they're in custody, protected from harm. And this deep dive into Ubuntu, fostering dignity, reinforcing rights, encouraging reintegration, it isn't just theory. It's a systemic shift. It's not just tweaking procedures, it's changing the whole approach. And it also aligns South Africa with its international obligations, things like the UN Convention on the Rights of the Child.
So meeting global standards, too.
Exactly. It's not just internal navel-gazing. It's about meeting global best practices for protecting children.
Okay, one of the areas where this shift seems most dramatic is around defining a child's criminal capacity. Can you explain how the Act fundamentally changes this concept, particularly regarding the minimum age?
Yes, this is a critical legal concept. And a major departure from the previous common law. Under the old system, it was possible, believe it or not, for very young children to be found criminally responsible.
Really? How young?
Yeah.
Potentially quite young. But the Child Justice Act draws a very clear line now. It states unequivocally, a child under the age of 12 years simply does not have criminal capacity. Period.
Under 12, no capacity, full stop.
Correct. Which means they cannot be prosecuted for an offense. Instead, if they're involved in an alleged offense, the process is completely different. They must be referred to a probation officer. They're dealt with entirely outside the formal criminal justice system.
Okay, let's make that practical. Picture a police officer encountering a child, maybe 10 years old, suspected of shoplifting. What happens first? No arrest, right?
That's absolutely correct. No arrest. The police official's first duty is to immediately hand the child over, either to their parents or what the Act calls an appropriate person. That could be a sibling over 16, a caregiver, or even a suitable child and youth care center if needed. And critically, a probation officer must be notified straight away. Immediately. That officer then has 7 days to assess the child. Based on that assessment, they can refer the child for counseling, maybe accredited programs, support services, or sometimes it might just involve arranging a meeting to understand what happened. The key insight here, the really crucial distinction, is that nothing done at this stage implies criminal liability.
Ah, okay. That's important.
It prevents a child from being labeled a criminal for what might be, an innocent mistake or even a cry for help.
So that's the clear line for under 12s, but things get a bit more complex as children get older, don't they? What about that tricky age group, say 12 or 13 years old? How does the Act handle them?
Right, for children who are 12 years or older but under 14, the Act introduces a powerful legal presumption. They are presumed to lack criminal capacity.
Presumed to lack it. So the default is they're not responsible.
Exactly. The burden of proof shifts entirely onto the state. The prosecution must prove beyond a reasonable doubt that the child, at the time of the offense, actually had the capacity. Did they understand right from wrong? Could they act accordingly?
And how do they prove that?
It involves a really comprehensive assessment, looking at their cognitive development, moral understanding, emotional state, psychological maturity, social background. Often, this requires an evaluation by a qualified person, like a child psychologist.
Okay.
And if the state can't prove that capacity beyond reasonable doubt,
Then what?
then they're dealt with similarly to the under 12s. Through those non-prosecution measures like referral to a probation officer, this whole tiered approach, distinguishing between these age groups, it's a fundamental thread running right through the Act. It guides how children are treated at every single step.
Okay, let's move on to one of the most maybe talked about features of this Act, diversion. What exactly does that term mean in this context, and why is it considered so central to the whole philosophy?
Right, diversion. In simple terms, as our source defines it, it means taking a case involving a child away from the formal court procedures.
Away from the court.
Yes, diverting it onto a different track. The objectives here are really profound. It's about encouraging accountability, yes, but without the stigma of a criminal record. It's about helping reintegrate the child into their family, their community, and ultimately reducing the chances of reoffending, breaking that cycle we talked about. It focuses on rehabilitation and restorative justice, not just punishment. It aims to promote their dignity, their well-being. Think about it from a young person's perspective, right?
Yeah.
Instead of being dragged into a formal court system for maybe a minor offense, which could stick with them for life, the Act offers them an alternative path, a chance to make amends differently.
It sounds incredibly progressive, really designed to help children learn and move on. But I can imagine some people hearing diversion and worrying, is this just letting kids off easy, a slap on the wrist? How does the Act ensure there's real accountability, but without resorting to punishment?
That's a really important point, and the Act anticipates that concern. It's definitely not a get-out-of-jail-free card, as they say. There are key conditions that must be met for a child's case to even be considered for diversion.
Okay, like what?
Firstly, the child has to acknowledge responsibility for the offense. Now, it's important to note this is an acknowledgement, not necessarily a formal admission of guilt in the legal sense. That's to protect them if diversion later fails.
Ah, a subtle but key difference.
Very key. Secondly, there needs to be prima facie evidence they committed the offense.
Prima facie, meaning?
Meaning, basically, on the face of it, there's enough initial evidence to suggest they likely did it, even before a full trial.
Got it.
And thirdly, and this is crucial, both the child and their parent or guardian must consent to the diversion process and the specific program.
Consent is required.
Absolutely. And diversion isn't just one person's decision. Prosecutors can divert cases early on. Preliminary inquiry magistrates can divert. Even a child justice court later in the process can opt for diversion before the prosecution finishes its case. Multiple opportunities.
I see the sources mention different levels of diversion options. Can you give us some examples? What do these look like in practice?
Sure. The levels correspond roughly to the seriousness of the offense, usually based on schedules in the Act. For less serious offenses, often Schedule I offenses, you have Level 1 options. These can be relatively simple things: an oral or written apology to the victim, a formal caution from an official, maybe placement under a supervision order where they have to report regularly.
Okay.
Other Level 1 options could include community service, maybe fixing damage they caused or paying back money or returning stolen items restitution.
Tangible action.
Exactly. Then for more serious offenses, typically Schedules 2 and 3, you move to Level 2 options. These involve more intensive interventions. Things like compulsory attendance at vocational or therapeutic centers.
Like programs to address behavior.
Precisely. Sometimes this might even involve temporary residence at such a center or intensive therapy sessions. Level 2 also includes things like probation officer supervision with restrictions on their movement.
And what about those restorative justice elements you mentioned?
Yes, the Act specifically promotes things like family group conferences. This brings the child, their family, the victim, and their support people together
Wow.
to collectively discuss the harm and figure out a way forward. Victim-offender mediation is similar, facilitating direct dialogue.
That sounds powerful, addressing the human impact.
It's central to the restorative approach, healing relationships, not just punishing acts.
So a child agrees to a diversion program. What happens if they just don't do it, don't comply with the order? Does the case just vanish?
No,
Yeah.
absolutely not. There's a system for follow-through. Accountability is built in. There's a monitoring system, usually overseen by a probation officer, to track compliance. If a child fails to comply, an inquiry is held by a magistrate. Now, if the failure wasn't really the child's fault, maybe circumstances beyond their control prevented them, the order might just be continued or maybe adjusted slightly.
Right. Life happens.
But if the inquiry finds the failure is the child's fault, then there are consequences. The prosecutor can decide to go ahead with the original prosecution for the offense.
Ah, so prosecution is back on the table.
It is. Or the court might decide to impose a different, maybe more demanding diversion option instead. But here's the really big takeaway for the child, and this reflects that core philosophy we keep talking about.
Yes.
A successfully completed diversion order does not count as a previous conviction. It doesn't give them a criminal record.
That is huge.
It's massive.
Oh.
And furthermore, once diversion is successfully completed, a prosecution cannot be brought again for that same offense. Double jeopardy protection, essentially.
So it really allows them a clean slate.
Exactly. It's designed to protect their future, allow them to move forward without that lifelong burden of a criminal record from an early mistake. It truly reflects their restorative and rehabilitative goals.
Okay, so diversion is one path. But what about cases that aren't diverted by a prosecutor? They move to something called a preliminary inquiry, right? Our sources describe this as an informal pretrial procedure which is inquisitorial in nature. Can you unpack that a bit? What's its main goal?
Certainly. The preliminary inquiry is a really crucial gatekeeper in the whole system. It's presided over by a magistrate. When they say inquisitorial in nature, think of the magistrate less like a referee between two opposing sides
Okay.
and more like a neutral investigator. They're actively involved in gathering facts, asking questions, understanding the full picture.
So they're digging into it themselves.
Exactly. Its objectives are multifaceted.
Yeah.
First, to consider the probation officer's assessment report, which is vital. Second, to determine if diversion is still a possibility at this stage. Maybe it wasn't suitable initially, but now it is. Third, to identify the most suitable diversion options if it is appropriate. Or fourth, to decide if the child needs to be referred elsewhere, maybe to a children's court, if it looks like a care and protection issue, not primarily a criminal one.
I see.
And finally, if none of those apply, to decide if the matter should proceed to a formal trial in a child justice court. The whole process is designed to be child-friendly, encourage their participation, and make sure all relevant information is on the table before big decisions are made about their release or placement.
And speaking of placement, when it comes to potentially holding a child in custody, what's the Act's fundamental approach? Is it lock them up first, ask questions later?
Absolutely not. The Act couldn't be clearer on this. It strongly prioritizes the least restrictive option possible.
Least restrictive.
Always. That means a clear preference for releasing the child, maybe on a written notice to appear later, or releasing them into the care of a parent or another appropriate person, or perhaps on bail, or even their own recognizance if they're older.
So keeping them out of detention facilities is the goal.
It's the primary goal, reflecting that constitutional right we mentioned. Detention should only ever be a measure of last resort, and always for the shortest appropriate period.
But presumably, sometimes detention is deemed absolutely necessary. What happens then? Where are children actually held? I've seen mentions of police cells, even prisons, which honestly sounds quite concerning given the Act's focus on children's rights.
It's a very valid concern, and it highlights why the Act puts in place a very specific, layered approach to placement, always aiming for what's best or least detrimental for the child. The number one preference, if detention is absolutely unavoidable, is a child and youth care center.
Okay, a dedicated facility.
Yes, a facility specifically designed for young people, offering care, support, and rehabilitation programs, not just containment. Using police cells or lockups is strictly limited. It's only considered under very specific conditions. Typically, only for older children, those aged 14 and above, and usually only for the more serious offenses, Or sometimes, if a suitable child and youth care center just isn't available in that area immediately, but it's meant to be short-term.
And prison, when would that ever be considered?
Detention in an actual prison is framed as an even more extreme, exceptional measure. It's reserved only for children aged 14 or older,
Okay.
and only if they are accused of the most serious offenses, those listed in Schedule 3. And even then, only if detaining them in prison is deemed absolutely necessary for the interests of justice or public safety. And there's a strong likelihood they'll receive a prison sentence if convicted. It's a high bar.
So multiple conditions have to be met.
Yes.
Good.
And even when a child is placed in prison pre-trial, there are strict conditions. Complete separation from adult prisoners, separation based on gender, access to visits from family, lawyers, immediate health care. Plus, any order for prison detention has to be reviewed by a magistrate every 14 days. It's not indefinite.
Regular checks.
Yes. And notably, the Act makes a strong stand against using leg irons on children. Handcuffs are only allowed in truly exceptional, justifiable circumstances. It's all about reinforcing dignity.
Okay, let's follow the path. If a matter isn't diverted, it goes to a child justice court for trial. What are the goals when it comes to sentencing children? Is it just about punishment then?
Definitely not just about punishment. The Act outlines very specific objectives for sentencing children, and they move far beyond simple retribution. The goals include encouraging the child to understand the harm they caused and take accountability for it, promoting an individualized response. This is key. Balancing the child's unique circumstances, their background, their needs.
Against the nature of the offense and society's interests.
Exactly, it's a balancing act. And critically, another major goal is to promote the child's reintegration back into their family and community. And the Act repeats that mantra. Imprisonment is to be used only as a measure of last resort and for the shortest appropriate period of time.
It really forces you to rethink what justice means for young people, doesn't it?
It absolutely does. It shifts the focus towards the future, towards potential.
So, with that philosophy, I imagine there's a wide range of sentencing options available that aren't imprisonment.
Indeed, a whole suite of options. The Act provides for many community-based sentences. These often mirror the diversion options we discussed earlier, things like community service, formal apologies, restitution, supervision orders.
Right, the focus is still on making amends and rehabilitation.
Precisely. Restorative justice sentences are also central options at sentencing. Formal family group conferences, victim offender mediation, these can be court-ordered sentences.
Interesting. So restorative justice isn't just pre-trial.
No, it can be part of the final sentence. Fines are technically an option, but the court has to specifically ask if the child or their family can actually pay. And there are alternatives if they can't, like symbolic restitution, maybe doing work for the victim instead of paying cash.
Okay. What about more restrictive options short of prison?
Yes, compulsory residence in a child and youth care center is another significant sentencing option. This focuses on structured rehabilitation, education, skills development therapy. It's time-limited, typically not exceeding 5 years, or until the child turns 21, whichever comes first.
And are there any hard age limits when it comes to actually sentencing a child to imprisonment? You mentioned under 14 for pre-trial detention.
Yes, and that carries through to sentencing. It's a crucial protection. A child who is under the age of 14 at the time of sentencing cannot be sent to prison, period.
Under 14, no prison sentence. That's absolute.
That's absolute under the Act. For those who are 14 or older at sentencing, imprisonment is still restricted. It's generally reserved only for the most serious Schedule 3 offenses, or if there are what the Act calls substantial and compelling reasons to impose it for a Schedule 2 offense, or even a Schedule 1 offense if the child has a significant record of relevant previous convictions.
So still very much a last resort, even for older teens.
Very much so. And even when a prison sentence is imposed, the length is capped, for example, generally up to 25 years maximum, even for the most severe cases committed by a child. And importantly, the Act mandates that no sentence of imprisonment should deny or limit the possibility of the child being considered for earlier release on parole or correctional supervision.
Hope is always maintained.
Exactly.
Yeah.
And any time they already spend in detention before sentencing must be taken into account by the court. It's a system designed always to look towards the child's future possibilities, not just their past actions.
This whole system sounds incredibly complex, requiring a lot of coordination between different players, police, probation, courts. What kind of support structures does the Act put in place to make it all work?
Well, first and foremost, legal representation is paramount. The Act is crystal clear. A child appearing in a child justice court must be provided with legal representation.
Must be.
Yes, even if it has to be at state expense through Legal Aid South Africa. And crucially, the child cannot waive this right. It's non-negotiable.
That's a strong safeguard.
It is. Beyond that, to improve coordination, the Act establishes the concept of one-stop child justice centers.
One-stop centers. What are those?
Think of them as integrated hubs. Ideally, you'd have a dedicated child justice court facility, along with offices for the police's child protection unit, probation officers, legal aid lawyers, diversion service providers, maybe health and social workers, all under one roof or closely linked.
Wow, so everyone needed is right there.
That's the goal. It promotes a truly holistic, collaborative approach between different government departments and also NGOs involved in child welfare. It streamlines the whole process for the child and their family.
That sounds like a really powerful way to improve services and ensure consistency. But let's talk about the long term. What happens to a child's record once they've gone through this system? Does a mistake made at 15 follow them forever, affecting jobs, travel, education?
This is such a critical question, isn't it?
Yeah.
It speaks directly to the rehabilitative heart of the Act. And the answer is one of its most profound impacts. The Act includes specific, clear provisions for the expungement of records, getting rid of them.
Expungement. How does that work?
For actual convictions, for less serious offenses, those in Schedule 1 or 2, the criminal record can be expunged, wiped clean, after a set period. It's 5 years for Schedule 1 offenses and 10 years for Schedule 2, provided the child hasn't committed a similar or more serious offense during that waiting period.
Okay, so for convictions, there's a path to a clean record after some time.
Yes. But even more broadly, and this affects many more children, the records of diversion orders are treated differently. Those records are automatically expunged when the child turns 21.
Automatically.
Automatically. Unless, of course, they've been convicted of another offense in the meantime, or they failed to comply with the original diversion order. But for the vast majority who successfully complete diversion, their record related to that incident effectively disappears when they become a young adult.
That is a massive aha moment, as you said earlier. It really embodies that second chance principle.
Absolutely. It means children can genuinely move forward without the lifelong stigma, the barriers that a criminal record from an early mistake can create. It perfectly reflects the restorative aims.
And finally, how does the Act ensure it stays relevant? That it learns and improves over time? Is there a mechanism for oversight and adaptation?
Yes, there is. The Act establishes a high-level body called the Intersectoral Committee for Child Justice. This committee brings together senior representatives from all the key government departments involved. We're talking justice, social development, police, safety and security, basic education, health.
All the major players.
All of them. Their job is to develop national policy on child justice, monitor how the Act is being implemented across the country, analyze trends in child offending, and, importantly, they're tasked with regularly reviewing key aspects, like the minimum age of criminal capacity, to see if changes are needed based on evidence and experience.
So it's a living system.
Exactly. It's got a built-in mechanism for continuous evaluation and adaptation. It acknowledges that our understanding evolves, societal needs change, and the law needs to keep pace to best protect and guide children.
So, wrapping this up, what does this deep dive into the Child Justice Act of 2008 really mean for you, our listener? It reveals a legal framework that's truly striving for a more humane, more rehabilitative, and fundamentally child-centric approach to justice. It's a complex system, yes, but one that deliberately tries to balance accountability with understanding the unique vulnerability and also the immense potential of young people.
And if you connect this to the bigger picture, it really demonstrates a profound commitment, on paper at least, to foundational human rights. It's a recognition that society ultimately benefits most when its youngest members are given every possible opportunity to learn from mistakes, to make amends, and to reintegrate productively rather than being lost to a cycle of crime.
It's been a truly fascinating journey, looking into how a legal system can actually be designed with compassion, with rehabilitation, and with forward-thinking principles right at its core.
Absolutely. And perhaps the ultimate provocative thought to leave you with is this. Thinking about this child-focused restorative model. In what other areas of our justice system, perhaps dealing with different vulnerable groups or different types of offenses, could a similar deep dive into restorative approaches and truly individualized treatment fundamentally transform outcomes, not just for the individuals involved, but maybe for society as a whole?